Franks indicated she spoke to Sarah Clay at SBI Lab. Estimated 60 days. Court in its discretion for reviewing available dates and everybody's availability. State's availability for witnesses and for attorneys, defendants, availability, potential witnesses, attorney, that July 27th was the date for trial. If we're talking about a separate issue of misleading the court on some reference, then I'll address that as a separate matter. But I know that I heard the objection at that time of the defendant, and as to being ready for trial, and at the earlier court date, court heard some arguments about the length of time it had been since the charges were initiated up to the time that it was initially set for trial earlier this year. Also, how it impacts the defendant as to whether the defendant would get credit toward his federal time for his state time and that sort of stuff. I believe we didn't fully grasp all of that until I believe Mr. Don, and we had an in-chambers conference, and he done some more research on that. But those issues were at play. The court, over the objection of the defendant, in the court's discretion, set the matter for July 27th. The matter started July 27th. Ms. Franks is here in the courtroom. She's standing up, and I believe she wants to put something of record.
Yes, sir, I do. I was informed there was an allegation of myself misleading the court as to Dustin Potpourri and the lab. Just would like to apologize first for appearing under these circumstances, but Kevin Bradley got appointed to Dustin Potpourri. He had trouble getting discovery. In fact, our office had to regenerate discovery because he could make no contact with Mr. Harrison's law partner or anyone in his office. Once that was done, then he had to get up with his client, which was through some difficulty because he was trying to stay out of Durham. Once he was able to get up with his client, we set up a meeting because for the lab to do the rush, they had to have DNA swab from Dustin Potpourri. That was done, I believe, May 6th or 7th. We actually got the sample from him. So then Mr. Bradley, once he got all the discovery, had questions and had to meet with his client before we could determine if I could meet with him and his client. And during that process and getting the stuff to the lab, I went out on medical leave May 19th. Did not come back to work until July the 20th. I was under the Family Medical Leave Act. So the only reason I did not meet with Mr. Potpourri or his attorney was because I was on medical leave. And at this point, I don't even know if Mr. Potpourri was still even willing to testify because Mr. Bradley's new attorney had to get into the case. And when I went out on medical leave, he still had not gotten completely through the discovery and actually had requested a couple more things in discovery. As far as the lab, did not do the rush because I went out on medical leave. And unfortunately, my medical health was more important at the time, and I followed all the proper procedures as far as going out on leave, filing it under the FMLA Act. So there was no misleading at all in the court. I'm bound by ethical rules that requires me to go through Dustin Potpourri's attorney which is the process I was taking, Your Honor. I was trying to follow all the rules correctly, and I cannot speak to a represented client without his attorney present or his attorney's permission. Therefore, prior to May 19th, I was not able to speak with Mr. Potpourri, although Mr. Bradley and I had spoken briefly about it as far as discovery, plea offer, and he needed to have a sit down with his client. Same thing with the lab. Once we got that sample May 7th, it was going to the lab probably May 15th, and I went out the very next Tuesday. And because of medical reasons that have been approved by the state, I was not here for 7 weeks, and the case was reassigned, it's my understanding, June 30th. But at no time did I, as an assistant district attorney, violate any ethical rules or mislead Mr. Charnes or anyone else. My intentions were, as I told the court, on those dates, and unfortunately my medical health dictated otherwise. And I apologize to the court for that. But my health with 4 children is a little bit a priority for me at this time, being a single parent.
Thank you very much.
Thank you.
I've heard what I'm going to hear on this particular motion, so you can sit back down.
Can I?
No, you can sit back down.
Can I put on the record?
Sit back down. A motion of this gravity will be put in writing, and you will assert all of the allegations that you make supporting that. And when you sign a document, you are attesting that you have evidence or reasonable cause, some sort of reasonable cause to sign that motion. And that would go for a motion that would be filed against anybody, whether it's the state against Mr. Charnes for allegations of intentionally misleading the court, which is what I'm hearing. So it needs to be in writing. The other side, it can be served. The other side will have an opportunity to respond in writing. And then I'll make a ruling on it. We'll have a hearing if that's what we need to do, and I'll make a ruling on it. We will not handle this by an oral motion at this point.
May I be excused, Your Honor, or do you need me further?
I don't know that I need you anymore, but that's what's going to happen with this motion. So that precludes putting something on the record regarding the merits of the motion. If you've got something that you want to put on record about the procedure, now's your time.
Yes, Your Honor. The DNA that I'm speaking of is from December 19, 2012. There were a number of items processed for touch DNA, not the DNA of Ladarius Riley that was done recently, or Mr. Potpourri that was done this summer, both those gentlemen. This is in the discovery. On December 19, 2012, I received a telephone call from Investigator Stroll, who advised that some of the officers' personal belongings that were seized from the scene in the hospital were going to be returned to him. He requested that these items be photographed and processed for possible touch DNA. So we got eyeglasses, cell phone. I'll go through the discovery, but I believe the badge and the cuffs, that was all done sometime in the time frame of 12/19/2012. That's what I'm referring to. Not something that was done recently, something that was done quite some time ago. And I'm happy to put this in writing, but what I'm speaking of is not what Ms. Franks just talked about.
Your Honor, in order for the SBI to do touch DNA, they have to have DNA samples from anyone that may or may not have touched it during that time period. As Ladarius Riley and Dustin Potpourri were co-defendants, and they were found with the defendant at the time of his arrest, then the State Bureau of Investigation requires that all 3 samples be sent. That's why the state had to get Ladarius Riley and Dustin Potpourri's sample even at this late date in order to send. It's the protocol that the SBI requires of the state.
Thank you. Anybody else have anything on the procedural aspect whether to hear it today or put in writing. Anything you want to put on the record, go ahead and put it on the record. It's limited to the procedural requirement that I say that motion, this particular motion has to be put in writing with all the grounds asserted and not served on the other side, and then the other side has the opportunity to respond also in writing. Anybody have anything they want to say or put on the record about that procedural approach?
Nothing from the state, Your Honor.
Nothing from the defense as to the procedure.
All right, thank you. You'll give me a second.
Actually, Your Honor, I do have a question about the procedure at the appropriate time. I see you're writing.
You'll give me a second there. What you want to put on the record there, Mr. Charnes?
As to the procedure, I guess I don't understand how I'm going to be able to, without issuing subpoenas, get folks from the lab. It may take someone from the SBI lab, someone from property and forensics to get them in here. As Your Honor remembers the testimony here, a lot of the witnesses came up to the stand, they didn't have their notes. That was a common thing. A couple folks did have their notes, but they didn't know when they did things, and they would need to have their notes. When I went to the property room, things were out and hadn't been returned. So my recollection, I don't have those notes with me when I went with my investigator, it was curious that after all this passage of time, that things weren't back from the lab. There were things that weren't there, is my recollection. So to really get to the bottom of this procedurally, I would need, in addition to the written order your Honor is requiring,
Written motion.
the written motion, Your Honor, that we need to get those records from property and have someone that could testify when things were done there. Because at least during this trial, the folks that would know those things didn't bring their reports with them. So just procedurally, I guess we can talk about that once I file my motion, but I'm trying to think how to actually be able to make a record without having folks not only from the SBI potentially, but from our forensic unit and our property room.
Well, every attorney that files a motion making an allegation about something attests that there's been some level of due diligence made. Now, it doesn't have to meet the other side's test of whether it's due diligence. It has to meet whether the court finds that it was an appropriate level of due diligence. That's every motion that is filed. There are lots of motions that are filed without fully knowing everything in advance. But one can't also stand up and make allegations unless there is some basis for doing it. And you've expressed some of yours. So, you know, I don't envision that we're going to have this big discovery thing, that I'm going to issue orders to prepare, get this evidence to you before there's a motion filed. I don't envision that right now, but once kind of the process is begun, if it meets some muster, then there are all sorts of opportunities that open up for judicial involvement to get people to appear and bring records, or whatever the case may be. But every motion of this nature has to have some sort of foundation, some sort of good faith foundation in order to bring it to even file. And it may prove that the good faith foundation was just that good faith, and it didn't work. It didn't materialize that what the good faith led the person to allege, or it may be that good faith effort unveils something that is certainly to be addressed by the court. But I'm just saying that put your motion in writing, put your allegations in as to what supports that, sign your motion, serve it on the other side. They have an opportunity to respond, and then we'll have a hearing if that's where all this leads.
Yes, Your Honor.
Thank you. Now, you had a second motion about the, was there another motion before we got to the motion on the insufficiency of the evidence?
Yes, Your Honor.
All right.
And that motion is motion to dismiss, and this relates back to the subpoena issued last Friday. The file stamp date on the subpoena should be in file, or it's downstairs to be filed, is August 7th at 9:33 a.m. This subpoena was given to the sergeant downstairs, and the normal procedure when you go to the sheriff's department, the sheriff tells you, why don't you give it to the sergeant? That's our process. So we did that. That didn't work. I saw in the paper that the chief said I hadn't been served with a subpoena, and so yesterday morning, as Your Honor recalled, Mr. Donovan said he went to the sheriff's office with copies of the subpoena to go through the process for serving subpoenas outside the Durham Police Department, and we haven't heard back. I did see the chief. I sent an email to Tony Smith, the police attorney, yesterday morning inquiring about why the chief wasn't here at 10. Over the weekend, I had sent emails to Patrick Baker, the city attorney, Mr. Bonfield, the city manager, and the police attorney, inquiring if they had issues about my subpoena and subpoena duces tecum. That, as always, I'd be happy to communicate with them. If they thought it was overbroad, you know, we would have that discussion. And I didn't hear back from them. So this, my client has, as I've argued, has the Sixth Amendment right to compel witnesses to get things for cross-examination. I didn't have that. They've rested. We made strategic decisions. and we will continue to make them, but I just want to put on the record for possible appellate review, my attempts to get the materials listed on the subpoena, and the subpoena speaks for itself, and that would be that part of the motion. I'll sit down, but I would like to be heard in detail on the motion to dismiss for insufficiency. I'm happy to answer any questions Your Honor might have.
I need to note, when you started out, you said a motion to dismiss related to the subpoena.
Yes, Your Honor.
The motion to dismiss all of the charges because the subpoena there was a subpoena issued for the Chief of Police of Durham Police Department.
Yes, Your Honor.
And do we know whether it has been legally served? That's going to be my first question. Do we know that yet?
I don't know my personal knowledge because I was working on these things. I didn't go to the sheriff's office, and what I find is there's a delay between service and actual knowledge before things are put in the court file. So in this case, we're actively trying this case. The subpoena with the return would be returned potentially to the clerk's office, and there's also the delay in getting it up here. But I do not know my own personal knowledge whether he has been served. He was talking about it to the news media, so certainly, obviously that's not service, but I don't know. I don't know the answer to that, Your Honor.
Well, what I have in front of me right now on the presentation of the motion to dismiss related to failure of the Chief of Police of Durham Police Department to respond to a subpoena is that I don't have any evidence that he's even been served with a subpoena that requires his appearance or requires a response to quash a subpoena or whatever the case may be. And without that, I have to dismiss deny any motion to dismiss. I don't know if there's been service yet. That's yet to be found out, and that may not justify dismissal of the charges as much as some other remedy that might be available. But at this point, presentation made, that motion is denied. Let me make that note here, Mr. Chairman.
Your Honor, may I revisit that if I find he's been served?
I'm just saying at this point,
Yes, Your Honor.
it's denied.
Thank you.
All right, and were there any other motions before we got to the motions regarding sufficiency of the evidence?
No, Your Honor.
All right, thank you.
So, turning attention to the motion to dismiss for insufficiency of evidence at the close of the state's evidence, and this would be directing attention to Your Honor to 13 CRS 68. It was a superseding indictment for robbery with a dangerous weapon, and the second count was assault on a law enforcement officer with a deadly weapon. And I will start at the count 2, and I'll wait till Your Honor.
Let me pull that file.
Thank you, Your Honor.
Superseding indictment dated March 2, 2015 in front of me.
Thank you, Your Honor.
Thank you. All right.
Directing your attention to count 2 which is the assault on law enforcement officer with a deadly weapon. So this is both insufficiency of the evidence argument, but the case law requires, if I'm arguing a fatal variance, that I make Your Honor aware of that, and I am. So it's both insufficient and a fatal variance. The allegation was attempting to run over the said officer and dragging said officer down the road. And the testimony was the officer jumped in and dove into the car. I would argue that this is a fatal variance. The evidence is...
What was that?
That was not me. And that was not thunder.
Or thunder, or lightning, or any of those things. Thank you.
So now we have birds, so which maybe
All right.
is appropriate. So that's essentially the argument. If we look literally what it says, that's not what the substantial evidence was in this case. And to use the magic words, fatal variance, which I've had to argue this on appeal without someone saying the magic words. So I again say the magic word, fatal variance. Literally what is alleged was not the proof, and it's insufficient in that there wasn't substantial evidence of this alleged crime of all the elements. And I don't know how Your Honor wants to handle it.
Well, let's do them one at a time.
Yes.
And let's, so right now we're focusing on 13 CRS 68, superseding indictment, count 2, assault on a law enforcement officer with a deadly weapon. The allegations being that the defendant assaulted K.A. Stewart, a law enforcement officer of the Durham City Police Department, with an automobile, a Nissan 300 SX, which is a deadly weapon, by attempting to run over said officer and dragging said officer down the road. At the time of the assault, the officer was performing the following duty of that office: attempting to conduct a traffic stop. What I'm hearing from Mr. Charnes is that his recollection of the evidence was that that there was no evidence about attempting to run over the officer and dragging the officer down the road.
Yes, Your Honor.
All right, thank you. Let me hear from the state on that motion.
Your Honor, the state respectfully asks the court to deny the defendant's motion. Specifically, when Investigator Stewart testified, he testified that he was forced to jump onto the door frame and was hanging onto the driver's door. He did not want to fall off and or get run over, was specifically what he said, that he was hanging on for his life to avoid being run over. Furthermore, another witness testified that the distance from where the officer's items were found and where his car was, I believe, was approximately 177 feet.
Wait a minute, say that again. Where his items were versus the car. At what point are you referring to there?
The distance from Investigator Stewart's vehicle to where Investigator Stewart's chain, shoe, glasses, cap, and those other items were found. One of the witnesses testified that that distance was approximately, I believe, 177 feet, which does imply that there was some movement whereby Investigator Stewart was hanging on for his life to avoid falling off, getting run over, hitting his head, and otherwise being injured. He held on to avoid being dragged. The state would ask the court to view this evidence in the light most favorable to the non-moving party and let this matter go to the jury. This is indeed a jury question for them to decide whether the state has proved this element beyond a reasonable doubt. Simple virtue of the fact that Investigator Stewart did not let go and actually fall off would not be enough to avoid sending this count to the jury. In the state's opinion, we respectfully ask you to deny the defendant's motion.
Thank you. In reviewing my notes on August 3rd, Officer Stewart, just my notes of that, and they refreshed my recollection, was that Officer Stewart testified that he reached into the motor vehicle to grab the defendant. And these are my words, not necessarily his, so that they can, but to get him out of the vehicle, that the vehicle took off. That Mr. Stewart was between the door and the car facing, that he was sort of standing on the door frame and holding on to the door. He feared he'd fall and hit his head, but he couldn't back away. He did not want to be dragged by the motor vehicle. He was committed to grabbing the defendant inside the motor vehicle. That's kind of, and that he worked his way into the car. So that's kind of what the question is that if, and that was the only testimony that I recall that dealt with that. Now there was this other testimony that I believe Ms. Strong indicated that their car was in one location, and he said the car was parked sort of to the back and left of his police vehicle was parked to the back and left of the vehicle driven by Mr. Riley. And if you use that as a starting point, and then there was some distance where his body was in the observed in the parking lot, that distance. And so the question comes, is there evidence that if I took that in a light most favorable to the state, could I, does it support the allegation of an attempt to run over the officer and dragging the officer down the road? That's kind of the question to me. There's evidence certainly that when the vehicle moved, Mr. Stewart was with the vehicle. That was his testimony. And at one point he was between the door, this is out the testimony, between the door and the door frame, that he feared he would fall back and hit his head. And he did not, he couldn't back away because he didn't want to be dragged by the motor vehicle. And does that constitute dragging the officer down the road? That's that scenario as described by Mr. Stewart, and I'm required to give at this stage to look at it in a light most favorable to the state as to whether it passes muster, as well as whether it matches up with what the allegations are. And the allegations are of some importance because they're a difference in the event alleged and this is generically, the event alleged, identifies what the charge is. In case there are multiple charges that are the same, it's the event description that kind of keys into whether to identify, for double jeopardy reasons, for lots of reasons, what the charge is. So the question is, and as I'm assessing this, is holding on to the door is fearing you fall and hit your head. Was sort of standing in between the door frame, and he was holding on to the door and door frame. And fearing that you might fall back and hit his head, and then working his way, and then later working his way in his car. Does that constitute dragging? Depends on what it is.
It's his motion.
Yes, Your Honor. The problem, as Your Honor identified it, is exactly what the issue is, the only issue here. So you have the double jeopardy issue, you have the due process clause of the United States Constitution, you have Article 1, North Carolina Constitution, various provisions about notice. And this variance issue is a little bit different from the insufficiency, because what exactly they said, as Your Honor pointed out, attempting to run over said officer and dragging said officer down the road. By no normal usage of the King's English, or not the King's English as it is now, can this testimony be said to be the officer who was dragged down the road and attempting to run over him. This officer, and again, as Your Honor stated the right, and they stated the right way to view this, giving them the benefit, but the officer violated all these rules, as we've discussed, but the allegation is both. It's not disjunctive, it's conjunctive. That's the allegation. And they don't meet it. He wasn't dragged down the road. And it's for the jury to believe other things about what that might mean, but this particular allegation is very specific, and it's and. It's not disjunctive. It's not this or this. And that might be a different case, but it isn't. This is what they've alleged. This was alleged, I mean, there was a superseding indictment March 2nd, 2015, not due to this. This was the original indictment that goes back to 2013. I believe it was sometime in January, you could look and see. So this is an allegation in the second count that standed 2 lawyers before I ever got in the case, that's been there from the very beginning. And what we prepared and what I did as a lawyer was based on this indictment, not something else. It was based on this. And the Constitution, as well as North Carolina, just our basic statutory law of insufficiency and the case law developed, doesn't allow this to go forward on this allegation because of this fatal variance.
Thank you. Ms. Ellis.
Your Honor, with all due respect to the court, our notes actually stated that the officer stated that he didn't want to fall back, hit his head, or get run over. Your Honor, I think that the operative word that we're missing here in counsel's argument is that there's an attempt. And in that charge, the state is alleging that the defendant attempted to run over and drag the officer. And, Your Honor, based on the totality of the circumstances and the events of the way that they had, and the officer's positioning, it is reasonable to believe that a person gunning their vehicle would know that they could have the potential to run over and drag the officer. And based on that, Your Honor, in light most favorable to the state, we would request that this be denied.
Thank you. Agree with y'all just now? Right. The motion to dismiss count 2 is allowed. Any other motions?
Yes, Your Honor. As to count 1, robbery with a dangerous weapon, this was, again, a superseding indictment, and I believe the thing that was added from the original indictment, my recollection is that originally I think the firearm wasn't alleged, but in any event, this was March 2nd, and we've had this now over 4 months. So, and the allegation involves the cell phone, the handgun. Well, Your Honor has it in front of you. I'm not going to read it, but what my argument is that the badge and the handcuffs, as I'm recalling the testimony of the officer, his testimony was, at one point he said the badge was on his belt, and then later he changed, his testimony was that the badge was on a chain, and during the struggle and the battle, as he described it with my client, the badge came off and fell in the car. That's also my recollection of his testimony about what happened to the handcuffs, that they fell to the floor. And the testimony about, Ms. Hikes, she heard the pop, looked immediately. Mr. Officer Stewart was in the car. My client, she described it, was outside. The gun was in the air. Officer was pulled out. So, Your Honor, as to the handcuffs and badge, that's a different situation than the handgun. So could I start there and then, or do you want me to make both arguments?
Make your whole argument, please.
Thank you, Your Honor. So as to the badge and handcuffs, they fell to the floor. The possession of the gun is unrelated to that. We've given notice of self-defense, and we've argued about that. I think there'd be evidence to go forward on larceny from the person, but as to the armed robbery, I would argue that there's not substantial evidence as to each element of an armed robbery. Certainly when in this particular situation where the officer testifies, get back, I'm going to shoot you, I'm going to shoot you, when he's disarmed and my client takes it away with the gun in the air, that's not an armed robbery. So there's many layers to it. The allegation, again, is he took the handgun, the badge, and the handcuffs with the use of the weapon. And I would argue that there's not substantial evidence as to each element of a robbery with a dangerous weapon under these circumstances as testified to by the officer. Everything from my client didn't stop the officer stopped him. And then there's a differentiation in the evidence between the badge and handcuffs. How it got in my client's hand, according to the officer, certainly badge and handcuffs on the ground. Also the cell phone, in the light most favorable to them, there's a cell phone that's found out on the road. The handcuffs and the badge were also found a day later. I think all three of those things were found a day later. There's just not substantial evidence as to those things, that being an armed robbery. And I would argue as to the gun itself, that under these circumstances, there's not substantial evidence of an armed robbery, every element of every offense here, based on what the officer testified he did and my client did. Thank you, Your Honor.
Thank you. That motion is denied. Which one do you want to go to next?
As to the remaining
I'm sorry,
charges,
Mr. Charles, if you give me more.
Yes, Your Honor.
Thank you, Mr. Charles. Which one do you wish to address next?
As to the remaining charges, I would just leave it at my argument that the state has not met every element of the remaining offenses.
Thank you. Those motions to dismiss for insufficiency of the evidence as to those remaining charges are denied. All right, any other motions that we have pending right now?
Your Honor, we filed, this isn't, it's to be done later, it's on Your Honor's list. I filed in file stamped and served opposing counsel with an affidavit from Stuart Fisher, along with his CV and my CV that relates to the earlier motion, the verbal, non-written motion by the state prior to opening to have me removed as counsel. And there's nothing to be heard on that at this time based on Your Honor's previous rulings and advice about the procedure. Also, I asked Mr. Donovan to check with the Sheriff's Office, and if you
I've got an update for you on
Yes,
that, which I'll get to, but are there any others in addition to the subpoena one?
No, Your Honor.
Anything from the state? Taking an inventory of the motions we need, or matters, non-jury matters, or out of the presence of the jury matters that we need to address this morning, and then we'll kind of address those.
Your Honor, we did want to put one thing on the record for edification, and that is that we wanted to put on the record that the state did not provide the medical records in the document review for the exhibits that went to the jury yesterday.
All right, so the, what you want to put on record is that the Duke University Medical Center medical records were not published to the jury yesterday. Correct. With those other
correct
documents. All right. Thank you. You got that on record. All right, as to the subpoena issue, Mr. Gray indicated to me that someone from the Sheriff's Department had advised him, so he's just passing the message on to me that the subpoena, when delivered, was already expired as to the time to appear. And as y'all will recall, I asked that question yesterday, Mr. Donovan, about what was the date and time on the subpoena. That was the response I got, so that if there's a new subpoena, they'll process it and serve it. That's what the message that came to our bailiff. He's just a conduit of messages. To me, I wanted y'all to know what he said. Mr. Gray, does that accurately summarize?
Yes.
Okay, thank you. All right, Mr. Charnes, you're standing, so let's hear what you'd like to say regarding that.
Yes, Your Honor, the subpoena, because of the issues of not knowing when a witness might have to appear, as I have call attorney for telephone standby. I also have date to appear produced, 8/10/2015, week to week until completed.
All right, I need to see a copy of the clock-in subpoena. All right.
Well, if you have notes on the back, you can't give it up to the judge.
All right, well, we're seeing if we can get that retrieved from the Sheriff's Department.
Accepted. The file stamped copy with no notes on the back. I'll show to the prosecution.
State.
Thank you, Your Honor.
And approach.
Yeah. Thank you. Mrs. Sippel, can you radio Mr. Gray that they found a stamped file copy? All right, either of you wish to be heard on whether this is a valid subpoena to be served? Really, it's not, the state really doesn't have a dog in the fight right now. It's a matter of the defense convincing me that this is a subpoena that can be served because of the language week to week until completed, the date to appear and produce 8/10/2015, week to week until completed, or whether a new subpoena has to be done, and then whether the party who receives the subpoena would sort of be the one that would complain. I guess unless we delayed everything extensively for a subpoena to be issued, then I think the state probably does have some grounds to at least express that. All right, Mr. Charnes, your opinion is that putting date to appear August 10, 2015, week to week until completed is adequate to serve at any time on or after August 10, 2015.
Yes, Your Honor, and read in conjunction with underneath asking for the warning tickets and training materials in parenthetical so as not to burden the people we issue subpoenas to. It's customary I put in there call attorney for telephone standby. Because obviously we don't know our schedule. And just as their witnesses were sequestered, my witnesses were sequestered, and the police chief were not on the type of terms he's going to call me up anyway. He would have his police attorney. And that's why I sent the emails and had communications with them, as I often do. And so those two things together, it's very enough. If I have copies of the emails, I'll either put them into the record now or later, but it's clear to me that this is a subpoena for many weeks, as long as this trial would go.
The question, oftentimes subpoenas have a date to appear followed by language of day to day or week to week or whatever it is until the case is completed. Rather than having the individual show up at the appointed time and just wait weeks and weeks until called. The question comes, however, is it reasonable for the Sheriff's Department to not serve it if the beginning date is August 10, 2015, and that at 10 o'clock a.m. and that time passed before the Sheriff's Department had it to serve? And as I recall our conversation, that you undertook the less formal procedure that you understood had been in place. I don't know it, so one way or the other, but that you had used before and understood was in place of giving it to a sergeant who notified the chief of police. And then when that wasn't done, I believe it was after 10 o'clock a.m. on August 10th that it was delivered to the Sheriff's Department. I'm going to find that it's not unreasonable. So what for the sheriff not to serve that with that beginning date, but if you want to re-subpoena, and I guess probably by the time you get it to, let me return that to you.
Thank you, Your Honor.
By the time you get it to, it should be fairly well in your system there. It would seem that tomorrow at some time would be the time. to put on there. I'm not sure if it's delivered to the sheriff's department. I don't know what the chief of police's schedule is, whether he's even available to be served. I know there's, at least from many years of experience, there is some process that the sheriff's department goes through to record things and assign a deputy to serve, and then the deputy has to physically go deal with that. And this is one that has to be personally served because it has the document request associated with it. The telephone service would work on just appearing, I believe, is the way I read the Rule 45 on subpoenas. But the other request, I think, does require personal service. And so I think that's where we are on that it would need to be reissued. And to avoid that same issue, you may want to set it for tomorrow at some point rather than, and it doesn't have to be at the beginning of court, it can be at another time during the course of the day. There's nothing that requires in the statute or the rule that requires that you only put the beginning of the court session for the day as the time to appear. So anyway, so there's a little bit more that has to be done, but I think that's where we are right now.
May I make, not to, I know you're on a rule, but to make a statement for the record for potential appellate purposes?
If it deals with a legal matter, yes. If it deals with a personal matter, probably that doesn't really preserve the record unless there's some legal reason, and sometimes personal goes over into legal. I'll let you exercise your judgment as to that.
Just briefly to make it clear, the process when in the past 2 years when I've gone to the sheriff's office to serve subpoenas on the police department, they said, well, we don't take those, take them to the sergeant. So just to let Your Honor know that, also that this trial there's a TV camera here, it's a live stream, there's a Herald Sun, a local paper, the News Observer. This is not a case where we're hidden off in this courtroom. So is it the second floor where the service folks are? First floor. So just to put on the record, because the appellate court, if it gets there, might not know this, just to put those things on the record, and that I followed the procedure, both procedures. And I'll sit down now. I just wanted to let the record reflect those things that might not be on the record.
All right. Thank you. Any other motions, including motions in limine, we need to address while the jury is out? I want to take full advantage of this opportunity.
Your Honor, at this time, I have a written motion in limine that I haven't filed that would go along with the jury instructions, but so if you want us to start talking about closings now ahead of the game, I'm happy to have a motion in limine that I'd like to be heard. It doesn't have to be heard now, it could be heard later.
We've got the jury out. Let's take advantage of anything we can, if we possibly can. I know I just deferred one, but anything we possibly can that addresses sort of the smooth continuation of the trial. I'm making notes on my rulings and that sort of thing like that.
Your Honor, I will say that the state has not received any motions at all today from counsel. I just want to put that on the record.
And I have not served them with my jury instructions, and this particular motion in limine that involves statements that the state may make during closing about the allegedly missing firearm from the officer. And so that's what it's about. I'm happy to talk now or talk later. about it as Your Honor wishes.
You have a written motion to that?
I have a written, it's simply a listing of, on the cover sheet with.
Let's get
jury
a copy of
instructions.
whatever's written over to the other side and give them an opportunity to look over it, and then I'll hear from both sides as to whether they're ready to hear it or not ready to hear it, or have a hearing on the merits. So do we have copies to give to the other side?
I do, and it's along with my jury instructions. And the way I prefer to do this, based on the things that have happened during this trial, is to go downstairs and get them file stamped, and then come back.
Sure.
That'd be all right.
That's not a problem.
And so, if Your Honor wants to start talking about jury instructions, then I think this would be a fine time to start talking about them.
There is one issue I have to kind of address before we go into a detailed inquiry into jury instructions. We can do some preliminary, and I'd like to do, and I actually had it on my list to do some preliminary. But the question comes as to whether there's going to be evidence presented by the defendants, and which has some impact on jury instructions and jury closing statements, because if something comes up on evidence presented by the defense, that might change what a ruling would be. It may be premature to do that ruling at this juncture. So has that decision been made yet?
May I consult briefly?
Yes.
And
In fact, let's be at ease. That's not the smallest question to have a conference on.
Yes, Your Honor.
So we'll be at ease for, let's take, is 15 minutes enough for that?
Yes, Your Honor.
Would that also, Mr. Donovan, would that give you time to clock in what needs to be clocked in? All right. Let's be at recess for 15 minutes, Sheriff, and then we'll reconvene and continue on.
Court's at recess, 15 minutes.